Good afternoon. My name is Mark Goldfeder, and I'm the director of the National Jewish Advocacy Center. We're a nonprofit organization committed to advocating for the Jewish nation and the Jewish state as prisms through which people from all walks of life can learn about the dignity of difference, the power of coexistence, and the strength that comes from tolerance. Today, as we get ready to celebrate Pesach, Passover, the holiday of liberation that culminated in the exodus from Egypt and the return to our sacred heritage, the land of Israel, I want to talk to you about an ongoing case that involves that very same land of Israel, because in every generation we face challenges, and in every generation, with God's help, we overcome them. A few months ago in December, the chief prosecutor of the International Criminal Court announced her intention to launch an investigation into alleged war crimes that she believes may have been committed by the state of Israel in the quote-unquote Palestinian territories. I should note that she spends no time in her 110-page filing talking about Israel's need for security in the face of numerous terrorist attacks, but even setting that aside, here's why this case is important. In theory, if the prosecutor were to investigate and were to find that there were crimes committed and were to find that Israel's courts were insufficient for dealing with the issue, she could potentially drag Israeli officials and soldiers into the dock of the ICC. Now, here's the truth. Many of the allegations were already investigated by Israel and were untrue. And if there are crimes, the Israeli court system is fully capable of handling them. But more fundamentally, this investigation should not happen because, and I'll put it very simply before we go more deeply into the matter, only a state can charge another state in a case like this, and like it or not, Palestine is not a state under international law. Just ask them. They're constantly talking about the fact that they do not have a state. The prosecutor is fully aware that she is on very shaky legal ground here. And so rather than wasting a lot of time investigating, only to be told in a few years that she had no jurisdiction to be doing this, she asked the court to give a preliminary ruling on jurisdiction. She herself believes that Palestine, which acceded to the Rome Statute, the court's foundational document, in early 2015, is enough of a state for the purposes of transferring criminal jurisdiction over its territory to the court. Enough of a state is usually not a category. Now, for a crime to have been committed within a state, that state would also have to have defined borders. And so she seems to believe that the Palestinians can also unilaterally determine what their own borders are, and that the ICC can therefore investigate alleged crimes that were carried out anywhere in the West Bank, including Jerusalem. Israel, by the way, is not even a party to the Rome Statute, which really should make all of this a moot question, because first, the Rome Statute is a treaty. It's created pursuant to the rules of customary international law. Under customary international law, the ICC does not possess jurisdiction over the nationals of non-consenting third-party states that have explicitly declined to accede to the Rome Statute. This, by the way, is also the position of the United States and India and many others. Article 12.2a of the Rome Statute, which purports to establish ICC jurisdiction over the nationals of non-state parties, actually disregards the well-established principle in customary international law requiring a state's consent in order for a treaty to bind that state's nationals. There is no customary norm whereby states can delegate their criminal jurisdiction over foreign nationals to a treaty-based court without the consent of the accused states of nationality. For such a norm to exist, it would require a widespread consensus of states. And despite what anyone will tell you, no such consensus exists. Far from it. Around 1/3 of all states, which represent about 2/3 of the world's population, do not agree to this arrangement. So by definition, you don't have a customary norm. The state parties to the ICC are free to create this norm for themselves, but they utterly lack the capacity to impose it upon the rest of the world. A principle of customary international law takes precedence over a contrary provision contained in a treaty with respect to those states that are not parties to that treaty. I mean, the absurd fact that the treaty actually places more burdens on states that don't sign it than on states that do. That's not how international law is supposed to work. Consequently, Article 12, 2A of the statute, either ultra vires and it's void ab initio, it's void from the beginning, or alternatively, it has to be interpreted as being consistent with existing international law, which is to say that a prerequisite to have jurisdiction over nationals of non-state parties would be the consent of the individual's state of nationality, or alternatively, a referral by the UN Security Council. Neither of which has happened here, which is why we shouldn't even really be having this discussion. Right? Clearly, if no individual state or group of states can lawfully compel a third-party state to be bound by the terms of the treaty to which that state has not acceded, neither can a subordinate creation or an agent of those state or states, like the ICC, lawfully do so. But even if, for argument's sake, the ICC were able to assert jurisdiction over nationals of non-consenting, non-party states, that would certainly not be the case when a state party to the Rome Statute and a non-state party have actually signed agreements specifically precluding ICC jurisdiction. That's what happened with the Oslo agreements, but now I'm getting ahead of myself. The prosecutor asked the pretrial chamber to allow various relevant parties to make their case regarding the specific question of territorial jurisdiction, and 19 groups did so on behalf of Israel. I'm going to just take a few minutes and walk you through the 10 main arguments that these groups made in no specific order. The first argument is as follows. Under Article 12.2a of the Rome Statute, the term state was intended to mean a sovereign state pursuant to general international law, not to have some specific new meaning here. Palestine is not a state for the purposes of Article 12.2a of the ICC statute, merely because of its accession to the Rome Statute or its membership of the Assembly of State Parties. There's no such thing as a state just for the purposes of the Rome Statute or just for the purposes of this case. And therefore they cannot delegate their jurisdiction. Now, the customary test of statehood holds that a state must consist of 4 elements: a defined territory, a permanent population, a government that is in total control of the territory, and the capacity to engage in foreign relations. These elements are commonly referred to as the Montevideo Criteria. With respect to the first of the criteria, the purported state of Palestine does not exist because it lacks a defined territory. The extent of the territory is not fixed, the PLO having agreed during the course of negotiating the Oslo Accords to leave the status and the scope of the entire territory unresolved, with the borders left as a permanent status issue for an agreed-upon settlement at a later date. Second criteria, the state of Palestine does not fulfill is it lacks a discernible population. Again, absent the first Montevideo criteria, the absence of a bilateral agreement establishing a Palestinian state means that there is no discernible permanent population over which they could in fact have control. Number 3, the state of Palestine doesn't fill the criteria because it lacks a government that is in control of its own territory. Again, the bilateral agreements that establish the PA, the Palestinian Authority, expressly state that Israel maintains all residual powers and responsibilities that are not delegated to the PA. So, since it lacks all the other elements of the Montevideo criteria, including a government that is in total control, it also lacks the capacity to engage in foreign relations, again, as specifically dealt with in the Oslo Accords. The second argument is that the prosecutor seems to have fundamentally misunderstood the UN process and role here. The role of the UN Secretary General as a treaty depositary is a purely administrative one in nature. He or she is not invested with the competence to make any final determination on issues of substance, like whether an entity is or is not a state. The status of non-member state, observer state at the UNGA, non-member observer state, is also not determinative of whether the relevant entity met the Montevideo criteria, giving it the legal status of a state under international law, which leads you to the third argument, which deals with UN resolutions that the prosecutor seems to either misread or misinterpret. The UN General Assembly resolutions do not say that Palestine is an actual state, and nor are they binding law. Again, prosecutor claims, for example, that Resolution 6719, and I quote, reaffirmed the right of the Palestinian people to self-determination and to independence in their state of Palestine on the Palestinian territory occupied since 1967. If you read that language, we reaffirmed their right to self-determination. That is aspirational in nature. It does not grant Palestinians statehood status, nor could it, as General Assembly does not have the power to establish states. In fact, many of the member states that supported the resolution actually clarified that their vote did not constitute the recognition of an existing Palestinian state. Notably, for example, Italy said its vote was explicitly conditioned on Palestinian promises that Palestine would not use such a vote to join the ICC. Again, and going back to widely known criticisms of the United Nations, UN General Assembly resolutions are the product of a manifestly biased institution. The fourth argument is that even if we acknowledge that some Palestinians may have a right to self-determination, that does not amount to recognition of a Palestinian state, and nor does it contribute anything to the hard questions here of a defined territory with actual borders or legitimate sovereignty. Palestinians having a right to self-determination under international law does not, in and of itself, convey on a population the legal status of sovereign statehood. The fifth argument is that Palestine cannot delegate jurisdiction to the International Criminal Court, which Palestine, has never itself acquired. Specifically, the prosecutor seems to misunderstand the Oslo Accords. In short, the PA does not have and has never had any type of criminal jurisdiction over Israelis, as well as over settlements, Area C, and East Jerusalem. In other words, they have never maintained criminal jurisdiction over the area where they claim to be the sovereign. In addition, Oslo didn't limit their jurisdiction. Prior to Oslo, the PA had no jurisdiction whatsoever. The Oslo Accords, by providing a framework for future peace negotiations, necessarily imply that Palestine was not a state before the Oslo Accords, and its status of statehood depended on future negotiations. So, the Oslo Accords did not give the state of Palestine authority over the territory it now claims to control. And so, contrary to the prosecutor's opinion that, and I quote, limitations to the PA's jurisdiction agreed upon in the Oslo Accords cannot and should not bar the exercise of the court's jurisdiction in Palestine pursuant to Article 12.2a, the first time in history that any part of Gaza or Judea or Samaria came under any form of Palestinian administration was in the context of the Oslo Accords. And again, the limited powers and jurisdiction that Israeli authorities delegated to the Palestinian entity never included any criminal jurisdiction whatsoever over Israelis. The sixth argument is that far from belonging to the Palestinians, the land in question actually belongs to the Jewish state. Some brief history is in order. In 1922, the League of Nations mandate for Palestine established an area, which included the West Bank, to be a national home for the Jewish people. Article 6 of the mandate explicitly encouraged close settlement by Jews on the land. When the UN was formed, it affirmed these existing arrangements, and after Britain announced that it would leave the area, the UN proposed a partition that was not accepted by the relevant sovereign parties because the Arab world rejected it, which left the mandate lines unrevised. Scholars like Eugene Kontorovich and Abraham Bell have noted that under the international legal principle of uti possidetis juris, which is widely acknowledged as the doctrine of customary international law that is central to determining territorial sovereignty in the era of decolonization, emerging states presumptively inherit their pre-independence administrative boundaries. So international law clearly dictates that Israel, which is the only state that emerged at the time, inherit the boundaries of the Mandate of Palestine as they existed in May 1948. Israel thus has title to the land. So when Israel declared independence, it was immediately attacked by 5 Arab nations, none of whom had title to this land. The UN blamed the Arabs for the violence and aggression that was meant to undermine the resolution and forcibly take land. And by the way, at the time, the spokesman for the Arab Higher Committee agreed that they were correct. So if there ever was an occupation of Palestinian territory under international law, it happened between 1948 and 1967, when 2 of the invading Arab armies, Jordan in the West Bank and Egypt in the Gaza Strip, occupied territory that they had taken through aggressive action, the exact kind of action that international law does forbid. And that was, of course, territory that was part of the mandate for Palestine, and that was now, under international law, rightfully under Israeli title. So from 49 to 67, Jordan and Egypt literally occupied Palestine. The Green Line was drawn for no other reason than to mark off on a map how far two invading armies had managed to get. The armistice agreements themselves actually state that they were not ever meant to be actual borders. So to give meaning under international law to the quote-unquote pre-67 lines is actually to retroactively ratify aggression against the mandate and support occupation. So in 1967, Israel legitimately regains sovereignty in a defensive war, having never lost title. So now they have sovereignty and title. To quote former State Department legal advisor, Professor Stephen Schwebel, who later headed the International Court of Justice in The Hague, and I quote, "Where the prior holder of territory had seized that territory unlawfully, the state which subsequently takes that territory in the lawful exercise of self-defense has against that prior holder better title." Let me just summarize what we just said. In short, Israel was given land under a mandate that was never repealed. Two other countries attacked Israel and squatted on that land for a while. And then, when they attacked Israel again and lost, Israel regained the land she had originally been given. So Israel has exclusive title and sovereignty. From an international law perspective, this is not an occupation, and that land does not belong to Palestine. Building off of that premise, argument 7 is that Israelis also have a right to self-determination, which is somehow not talked about a lot by the prosecutor, and that includes the right to security. But we could spend hours discussing the immense historic and cultural importance of Jewish communities in Judea and Samaria, which is heavily downplayed by the prosecution. The prosecution ignores the continuous Jewish presence in these areas, which was only interrupted by Jordanian rule between 48 and 67, between 49 and 67, which, by the way, the prosecution itself calls an occupation. So in discounting the rights of the state of Israel and the Jewish people to these areas, despite its strong connection to their identity, she arbitrarily assigns them to a state of Palestine and implies that only Palestinians have rights there, including the right to self-determination, and that's simply not historic and not true. The 8th argument, this is quite an important argument in the subject of whether a Palestinian state exists, is the position that is consistently and publicly taken by PA officials themselves, that there is no state of Palestine. For example, on January 20th, 2019, Prime Minister Hamdallah stated, and I quote, "The very inception of a sovereign Palestinian state has yet to happen." Just a couple months ago, on January 29th, in response to President Trump's new peace plan, President Mahmoud Abbas said, and I quote, "We shall continue our efforts in our struggle in order to reach an independent Palestinian state." Okay? Statements like that should really put the issue to rest. If Palestinian leaders admit that there is no Palestinian state that currently exists, there's no reason for the international community or the ICC prosecutor or this court to disbelieve them or to try to construct novel arguments for why they really should be a state for some purposes. The 9th argument is that if you do adjudicate statehood in this case in this manner, you have a massively detrimental effect on the stability of other states that are then going to see secessionist movements that are suddenly granted legal legitimacy despite the fact that they don't otherwise meet the international law criteria for having statehood. And finally, the 10th argument is this. If you boil it all down, the prosecutor's argument is as follows. The normative criteria for statehood under international law should be ignored in this unique situation of Palestine because for reasons that she doesn't really go into, because there's no legal basis, they're not comparable to other entities. And that's, again, a highly controversial argument of exception for which there is no legal authority. But it's problematic for two reasons. First of all, it makes a mockery of the International Criminal Court. Again, the prosecutor's submission, her own filing, recognizes that, and I quote, "The issue of Palestinian statehood under international law does not appear to have been definitively resolved." That's generous, but that's a direct quote. In addition, the prosecutor acknowledges that the court's, and I quote again, jurisdictional regime is a cornerstone of the Rome Statute, and she stresses the importance for the court's own interest that, quoting again, any investigation proceeds on a solid jurisdictional basis. Okay, these statements by the prosecutor alone should be completely dispositive of this issue. By definition, an investigation cannot proceed on a solid jurisdictional basis when, by her own admission in the same filing, the underlying prerequisite international law questions have not been, and I quote, definitively resolved. And finally, it's problematic for another reason, because when you treat all states and all situations one way, according to law, but when it comes to Israel and the Jewish state, you change the rules in a way that treats Israel detrimentally, well, we have a word for that: anti-Semitism. I'm not accusing her of outright anti-Semitism, but the same institutional anti-Semitic bias that permeates the entire United Nations framework. I hope this gave you a little more insight into the fight that we're fighting at the ICC. I want to wish you all a Chag Kasher V'Sameach, a happy, healthy, and safe Passover. And in this season of redemption, may all of the sick be healed. May we see the liberation from this virus very, very soon. Thank you for tuning in. I hope that we can provide with an update sometime in the near future.